The satire site The Onion has filed a Supreme Court brief in support of a man who was arrested and prosecuted for making fun of his local police department on Facebook. According to the Associated Press, lawyers for The Onion wrote, as the Globe's premier parodists, The Onion's writers also have a self-serving interest in preventing political authorities from imprisoning humorists. This brief is submitted in the interest of mitigating their future punishment.
According to Bloomberg, the brief includes dramatic hyperbole and false declarations. Lawyers for the outlet went on to explain that filing a parody brief was the point. Joining us now to break down this story is senior attorney at the Institute for Justice, Patrick Giacomo. Welcome, Patrick.
Thank you so much for having me.
So this story has everything. It has parody. It has big kind of First Amendment claims. Can you start by telling us what the underlying incident was that provoked this lawsuit in the first place?
Sure. So this case arises out of aspiring comedic writer Anthony Novak sitting at a bus stop, waiting for his bus and deciding to put a parody account of his local police department on Facebook, which he did. And he posted 6 different posts. All of them were obvious parody. For instance, one was a post from the parody police department saying that it was now illegal in the city to feed any homeless people, hoping that they would all leave from starvation. Another one advertised a pedophile reform event where pedophiles could solve some puzzles and at the end would be made honorary police officers. So these were things that, unless the Parma Police Department has some real problems, no reasonable person would have thought were real. Nevertheless, the very stern police came on local television that evening and threatened that they were doing a criminal investigation to the page. And so 12 hours after he'd published it, Anthony took it down. But that was just the beginning of what actually happened, because over the course of the next 3 weeks, police got a bunch of arrest warrants and search warrants. And ultimately, about a month after Anthony had taken the page down, and without ever having reached out to him to ask him to take it down, frankly, they arrested Anthony, they searched his apartment, they seized his and his roommate's electronics, they jailed him for several days before he made bail, and ultimately they prosecuted him under a crime that they and prosecutors came up with in violation of an Ohio hacking statute that makes it a crime to use a computer to, quote, interrupt or disrupt police operations. Their theory here being that Anthony had used a computer to post on Facebook, true, and the disruption of police services was because a handful of people, 11, had called the non-emergency police line to tattle on the Facebook page. And the government in Ohio argued this was a disruption of police services that was a felony under Ohio law. And that was where all of this came from.
That's just so shocking and inappropriate. I think everyone, such an obvious violation of the First Amendment to, hassles. Like this cannot, it's supposed to be that this cannot happen in the United States of America because we have ironclad protections for just this kind of speech. So is this case as cut and dry as it would appear to, anyone who has even a passing familiarity of what the First Amendment protects?
Well, it should be. Unfortunately, the reason it isn't is because of the doctrine of qualified immunity. And so in this case, Anthony sued the officers and the department for violating his First and Fourth Amendment rights, freedom of speech and freedom from unreasonable searches and seizures. And the case, through a very long course, wound its way up to the Sixth Circuit Court of Appeals sitting in Cincinnati. And that court went through all of the First and Fourth Amendment discussion, and it said, obviously, parody is protected by the First Amendment. This is a core historic principle, like The Onion pointed out. But because of qualified immunity, there was no clearly established law that said that when Anthony deleted Facebook comments calling his parody fake, spoiling the punchline, that was protected. It wasn't clearly established. And therefore, the officers got qualified immunity, and the probable cause for his arrest was supported going from there. And so this case, which is one that now we at the Institute for Justice are petitioning to the Supreme Court about, which is what the Onion's brief is supporting, really goes to show that notwithstanding the fact that everybody, police officers and judges alike, understand that this sort of government criticism is protected as a core principle of the First Amendment, qualified immunity essentially means that people like Anthony, people like you and me, might have rights that are written down on parchment in the Constitution, but those rights are not actually enforceable in American courts.
I think that's so important because there is so much discussion in this country all the time. Oftentimes, by the conservative part of this country about First Amendment issues and overreach. But ironically, qualified immunity has been a sticking point in terms of criminal justice reform efforts. Even those criminal justice reform efforts that there have a lot of bipartisan consensus. The George Floyd Justice Act was derailed in large part because they couldn't get any Republican buy-in on qualified immunity. And when you see it in a case like this, which is obviously a much less serious case in terms of people's life, liberty interests than a lot of the kind of criminal justice context we're normally talking about it in. You really do see how it's used, how it's weaponized over and over again to keep police officers from playing by a different set of rules than the rest of the public. And in instances like this, when you see a police department literally bullying a member of the public over their ability to express themselves freely using a platform which has had its own controversies about the speechiness that's allowed on Facebook, and basically being able to get away with that bullying because of qualified immunity. I wonder, do you think this could potentially start to concretize for people why this particular insulation against consequences that the cops have is a real broader social problem?
Yeah, I actually do. At the Institute for Justice, we've been fighting a bunch of immunity doctrines for years now, chief among them qualified immunity. And as you said, the sort of pro-police crowd, the reflexively pro-qualified immunity crowd, has done a good job in the narrative of selling qualified immunity as something that it isn't, which is a necessary protection for police. But the thing to keep in mind is that qualified immunity protects all government workers, not just police. So mayors, governors, bureaucrats, code enforcers, IRS agents, people that typically conservatives don't
University
have the most love
administrators.
for. Yeah, exactly. School administrators. And this case is a great example of a situation that I think will resonate with conservatives and liberals and everyone in between, because they see the situation. And this is not the typical case where you need to cut slack for police to have breathing room. This isn't a late night with rain and maybe I saw a gun. This is a weeks-long campaign to arrest someone who made fun of the police. And it's worth noting that this decision, which was written by a respected conservative judge in the Sixth Circuit, is diametrically opposed by a recent decision from another respected conservative judge in Texas, who denied qualified immunity to police who arrested a Facebook journalist for asking them questions and said, these things are so obvious, there's no need for qualified immunity to provide fair warning to police because what they were doing was plainly wrong and they probably knew it was wrong. And the same is true here.
Yeah. Well, thank you so much for the work that you and the Institute are doing on this and other speech-related qualified immunity cases. We so appreciate having you on.
And we should say before we wrap that we kind of buried the lead a little bit insofar as the brief is funny. Like the Onion filed a brief written also in parody format, which I think there will be some interesting questions about whether or not that it makes it more effective, more people are going to pay attention to it, whether there's some social pressure here that will, in order of the public benefit, or whether or not people will treat it as a gag. But definitely go and check it out if you haven't looked at it already. And thank you again, Patrick, for joining us.
Thank you so much.
We'll have more Rising for you after this.